Welcome back to Global Politics. In this lesson, we're going to carry on talking about the importance of globalization and the impact on a number of different key issues within geopolitics more broadly, focusing in this lesson on the impact of globalization on human rights. So this continues our discussion of the impact of globalization on what I describe as different topics or different subjects or issues that go on and exist within geopolitics. We talked about the impact of globalization on global poverty in the last lesson. This lesson, we're going to spend some time talking about the extent to which globalization has upheld the protection of human rights. Now, a lot of the things that we're going to discuss in this lesson aren't things that we've not already discussed before, but we're just going to contextualize them through the lens of human rights, and specifically the impact of globalization on human rights. So I'm not going to be focusing on a lot of things that are entirely new that we haven't already discussed, but I will go over them again just for the purposes of contextualizing them within this particular lens. And so we can begin by talking about the fact that there has been an increase in political globalization. And so we have seen far greater protections of human rights within international law within the growing corpus of what we would describe as international human rights law. That is the sort of general set of rules and regulations that we see to protect human rights, essentially. So let's begin by talking about international human rights law. It exists through a number of different institutions, whether these institutions be regional, whether they be international, whether they have certain enforcement mechanisms, whether they have no hard power enforcement mechanisms, instead they are just soft power enforcement mechanisms. Regardless, there is a growing body of regulation within international human rights law. At the most broad level, we have the Universal Declaration of Human Rights, which is exhibited by the United Nations and provides a strong sense of protections for human rights and fundamental freedoms for essentially those who are a part of the United Nations. And they represent, however, a soft law indication of human rights. It's not necessarily something that is directly enforceable in every single context, but in a broad sense, the Universal Declaration of Human Rights is something that tries to provide for a soft power human rights set of human rights regulations. There are also a number of other human rights instruments and treaties that have been established subsequently in the growing set of human rights regulations. So, for example, we have the European Convention on Human Rights that is established by the Council of Europe at the end of the Second World War. We have the International Convention on the Rights of the Child, which is actually the most I believe this is the most widely ratified international treaty in the world. Almost every single country on planet Earth has either signed on and ratified the ICRC, which is the Rights of the Child Convention. Similarly, we have the International Convention on the Rights of People with Disabilities, again a very widely established human rights doctrine and human rights treaty. We also have the International Covenant of Civil and Political Rights, again another one that is widely ratified by lots of member states around the world. So this is just a very brief overview of the kind of human rights that exist within international law and the kind of human rights that we can talk about in terms of greater protections for certain rights, either at the international level in the sense of the Universal Declaration or the International Covenant, at a regional level in terms of the European Convention, and also within the realm of specific areas of human rights. So whether it be international child rights, which is the ICRC, or the rights of people with disabilities, which is the Rights of People with Disabilities Convention. Moving on then, let's talk about a different aspect of international law, specifically international humanitarian law. So international humanitarian law refers to the regulation and rules of customs and of hostilities during armed conflicts. So it's essentially the laws of war that we have in place. In a basic sense, what they do is protect a number of fundamental rights for people who are either combatants in an armed conflict, they are either non-combatants in an armed conflict, or those who are what we describe as hors de combat, who are people who were combatants but who have been removed from the classification of combatants due to a number of different things. They are out of action. So whether that be somebody who is, for example, a POW, a prisoner of war, or somebody who is wounded within an armed armed conflict situation. There are different rights for these individuals that are protected under international humanitarian law. And in this regard, there are a number of different instruments within international law that protect these rights and protect these individuals as well. So we have, for example, the Geneva Conventions and their additional protocols. There are 4 Geneva Conventions and there are 3 additional protocols, 2 of which are more important than the third. And these are the treaty regulations that are protecting the rights of people who are on the battlefield, or the human rights of individuals during an armed conflict. But then you also have the International Committee for the Red Cross with their rules on customary international humanitarian law. So this gives us this is a very brief sort of interlude that I'll just give right now. The distinction between treaties under international law and customary international law. So treaties under international law are what you would understand already to be what treaties essentially are. They are agreements that are made between countries that sign on to the particular treaty themselves, and they sign it and they ratify the treaty, and then they are therefore bound under international law to that particular treaty. The Geneva Conventions represent an example of treaties. Customary international law is a bit more of a nuanced discussion, because customary international law is something that represents the general principles and customs that are followed by states and by international institutions that are generally recognized to be customary practices that are accepted within international law. And so there are a certain number of customary rules of international humanitarian law. There are customary rules of the laws of war that are generally seen to be rules that apply to any state, regardless of whether or not they have ratified, for example, the Geneva Conventions. And the Red Cross has a very big list of these different rules. There's, I believe, like 140 or 150 different rules that apply that are considered to be customary. And these actually include the Geneva Conventions themselves. So while the Geneva Conventions are treaties, essentially, they are conventions, they are treaties that you sign on to and you ratify, they are so widely accepted in international law today that they are now considered to be not only treaties, but they are also considered to be customary international law. And there's a very interesting case that comes from what is known as the Ethiopia-Eritrea Claims Commission. So the reason why this is important is because essentially a civil war takes place within Ethiopia. Eritrea then becomes a breakaway state. So it becomes a country that has broken away from the state of Ethiopia and has now become its own internationally recognized state within international law. And the reason why it's important that the Geneva Conventions are customary as well as represent treaty law is because during this time between Eritrea and Ethiopia, there's still conflict going on between the two countries. And Eritrea hadn't, because it had only just come into existence, it had only just established itself as a state, it didn't have time to sign and ratify the Geneva Conventions. And so therefore the question was, to what extent are the people fighting in this civil war actually bound to the Geneva Conventions, considering the fact that Eritrea hasn't signed on to or ratified them? And the Claims Commission came to the conclusion that even though Eritrea hadn't ratified the Geneva Conventions because they didn't have time, the conflict that existed between Ethiopia and Eritrea represented a conflict where the Geneva Conventions still had to be bound to follow, because the Geneva Conventions had become customary international law. So that's just a brief interlude. You don't need to know that in any particular detail. But international humanitarian law protects those who are under who are regulated under armed conflicts, essentially. So that is what IHL does. As a separate part of international humanitarian law, we also have the issue of humanitarian intervention. So in recent years, we've seen a number of examples of states offering what is known as humanitarian intervention, where essentially a state goes into a conflict zone as almost a peacekeeping mission and as a way to try and either to prevent hostilities from taking place, or if there are hostilities going on, to try and maintain as much human rights protection as possible for those who are maybe civilians or non-combatants or those who are ordered to combat. We've also seen examples of actual violent humanitarian intervention. So, for example, the NATO bombings of Kosovo in 1999 to try and prevent the potential ethnic cleansing from taking place within Albania. We also see conflict going on and humanitarian intervention in East Timor between 1999 and 2000, in Sierra Leone in 2000, in Libya in 2011, in Mali in 2013 to 2014. We also see, as the result of humanitarian intervention, from a legal perspective, the establishment of a number of ad hoc and post hoc tribunals to prosecute international crimes, to prosecute genocide, crimes against humanity, and war crimes. These include the International Criminal Tribunal for the former Yugoslavia, which we've talked about already. We've talked about the International Criminal Tribunal for Rwanda, following the Rwandan genocide, as well as the special court that was established following the end of the conflict that was taking place within Sierra Leone, which was known as the Special Court for Sierra Leone. And these bits at the bottom here bring us into the next of the regulation of human rights from a globalist perspective, and this is within international criminal law. So, as I've mentioned previously in previous lessons, international criminal law is the study of the protection against the prevention of the worst crimes that, quote, shock the very nature or shock the very conscience of humanity. We can trace modern international criminal law back to Nuremberg and Tokyo with the Nuremberg and Tokyo International Military Tribunals. Nuremberg, of course, the Nuremberg trials that tried Nazi war criminals at the end of the Second World War. The Tokyo Tribunal, less known, but it should be known as the Tribunal for the Far East, is what it was actually officially called. But the Tokyo trials did essentially the same thing, but for the people who committed war crimes who were in Imperial Japan during the Pacific conflict in World War II. And while we can trace international criminal law all the way back to piracy regulation many, many hundreds of years ago, this was really where modern international criminal law begins. And so we do regulate international crimes that are including genocide, crimes against humanity, war crimes, and the crime of aggression. And so there also existed the ICTY and the ICTR, the Special Court for Sierra Leone. These are what known as the ad hoc tribunals. And today and since 2002, we have a permanent court of international criminal law. This is the International Criminal Court. We know that the regulation for the International Criminal Court is known as the Rome Statute, or the Statute for the International Criminal Court. And the International Criminal Court does essentially what the ICTY and the ICTR does, but in any jurisdiction. They have many, many, many cases that are on their docket. They are incredibly overworked, as you can probably imagine, and so that is what the ICC does to this day. And this is how we can see globalization, political globalization, protecting those against international crimes. So that's the one hand of the argument. What about critiques of globalization and critiques of the fact that human rights haven't been protected necessarily as a result of political globalization? Because while we can say that there are a lot of human rights protections due to an increase in political globalization, there is still an argument against this particular thesis, the extent to which globalization has even helped protect. And one example of this is, while the Universal Declaration on Human Rights is a strong instrument, it only represents soft law or soft power on this matter. And so therefore it is something that is not enforceable against member states by a particular institution. Similarly, while the International Criminal Court has been able to lead to a number of prosecutions, their processes are incredibly slow, and they are easily able to be blocked by countries who have not ratified the Rome Statute and are therefore not members of the International Criminal Court. And these include China, the USA, Israel, as well as the Russian Federation. These are all states that are very, very powerful states that have all had accusations levied against them of committing international crimes. Not necessarily the state, but individuals within the state. China, we of course know about the ongoing Uyghur genocide that is taking place. The USA has got many, many, many criticisms levied against them for example, the illegal invasion of Iraq. We also have illegal use of drone strikes in places like Syria. We also have war crimes claims being made against US soldiers in Afghanistan. Israel has many claims of human rights abuses when it comes to dealing with the territory of Palestine, especially in relation to potential war crimes committed, or crimes against humanity committed in 2014. And then, of course, the Russian Federation we have the March 2022 invasion of Ukraine, and subsequent to that, a number of war crimes have been uncovered as a result of that invasion and the actual pushback at time of recording of the Russian forces by Ukrainian military. And so, due to the fact that there exist permanent members of the UN Security Council, the institution itself, the UN Security Council, is also hampered by certain votes. So, for example, both the Russian Federation and China are permanent members of the UN Security Council, and this is problematic when the UN Security Council members, when permanent members of the UN Security Council, then start to break and commit serious violations of human rights and international criminal law themselves. It was very difficult, if you remember back to March 2022, it's very difficult, or it was very difficult, for the UN Security Council to really do anything significant in regards to the Russian Federation's invasion of Ukraine, because the Russian Federation is a permanent member of the Security Council, and any vote that requires unanimity among the permanent members and the additional members that are cycled through at the time, they were always never going to ever get that vote pass, because the Russian Federation would always veto any kind of vote that required unanimity. So we have, and again, similar things can be said about allegations of genocide in China against Uyghur Muslims. We have the 2014 annexation of Crimea by the Russian Federation, and the 2022 illegal invasion of Ukraine by the Russian Federation. So on the one hand, we can talk about all the different ways in which political and economic globalization has impacted and maybe helped or contributed to the protection of human rights within international regulation, within geopolitics. But we can talk about critiques of that, on the other hand, by talking about the limitations of all of these different human rights instruments in being able to protect against serious human rights violations on a global level.